was just very briefly then, if I may, to finish off the points on Mrs. Justice Thornton's judgment. The fifth point that she made was to conclude that the CCR, that's the report, was inconsistent on whether the project would lead to a net global reduction in emissions. That's 315 to 316, 329 and 334 in her judgment. And the answer to that, I think, is the one I've already given, which is that there isn't any doubt about that. That's a misreading of the CCR for all the reasons that were given below. Doesn't appear to have been pursued with any great intensity in this appeal. But there was no doubt in any event from the report that the project would lead to significant overall increase in Scope 3 emissions, but there were serious errors of judgment and doubt about precisely how that would all work out. See the judgment of Lord Justice Stuart-Smith on that at 177 to 204, and there was, of course, already the qualitative assessment indicating that there will be a very high level of Scope 3 emissions, as correctly recorded in 237 in Lord Justice Stuart-Smith's judgment. So that's point 5. Point 6 is a related one, could almost be point 5b, but point 6 is a related one. Mrs. Justice Thornton concluding that the material provided to ministers would reasonably have led them to believe that the project was likely to lead to a net global reduction in emissions and would therefore be beneficial. That's 318 to 319. That we respectfully disagree with. Lord Justice Stuart-Smith, we respectfully submit, was right to conclude that the submissions themselves made clear that the project would be likely to have significant, very significant impact in terms of GHG emissions. See his judgment at paragraphs 211 to 213. And you will recall I specifically drew your attention to paragraph 56E in the submission to the DIT minister, which summarised the conclusions in the report. But of course the key thing to bear in mind is that the ministers were provided with the base material from this perspective. They were provided with the report itself, and the Secretary of State for International Trade was specifically enjoined to pay particular attention to that. Recall paragraph 14 of that submission. And the proof is to some extent in the pudding, because as Lord Justice Stuart-Smith rightly recalls, at paragraph 91 of the judgment below, the result of the submission to the Prime Minister was for him to ask for consideration to be given to offsetting measures, and so appreciated that at least the likelihood is that it wouldn't be a below net reduction, or it wouldn't be a net reduction point. So that's the sixth point. The seventh point is that that ministers, Mrs. Justice Thornton concluded, were not given quantified estimates which would have conveyed the scale of the gross impact, depriving them of a legally adequate understanding of the scale of the emissions. That's 325, 333 and 336 in her judgment. And again, I've answered that. My submission is that the correct analysis is that a quantification of Scope 3 emissions in itself would have added little material to ministers' understanding, particularly in circumstances in which they knew that the emissions were very high, they had the report itself, and query what would have been added. The conclusion of Lord Justice Stuart-Smith was that that was not the position. See his judgment, 169, 170, 234 and 237. And he makes the additional point, which I respectfully submit is a fair and compelling point, which is that if you were to put in the quantification number, it might create a risk, if it's put in as an absolute number, it might create a risk of them getting a spurious, or understanding that the thing was spuriously precise, when in fact it wasn't. and in truth what was being done and what needed to be done was a relatively complex evaluative exercise to try and get to a fair picture of impact overall. And that leads into the final point, which is Mrs. Justice Thornton's conclusion that the report itself conflates, as she put it, Scope 3 emissions with avoided emissions. That's 306, 329 and 334 of her judgment. And the point about that, perhaps, is that it was really a question for those producing the report and for UKEF to try and work out how far it was appropriate to chase down all of these lines, what particular numbers and what particular analyses would in fact lead to useful or greater understanding of the issue that they were actively addressing, namely impact. As Lord Justice Stuart-Smith pointed out, UKIF were fully aware of the limitations of the CCR, C164 of his judgment, and as he also concluded, they were fully understood the difference between emissions and avoided emissions. In other words, that idea that if you export into certain markets, it might offset and all of that, and might lead to substitution of a less damaging fuel for a more damaging fuel. All of that set of issues, which were writ large on the face of the report itself. But fundamentally, this was a view that had to be taken about the best and most sensible way of trying to present a complex subject within a sensible and limited parameter. So we respectfully submit that the judgment and the conclusions of Lord Justice Stuart-Smith on this issue are to be preferred, and even if there were to be some force in some of the points that Mrs. Justice Thornton makes about the presentation and the inquiries that were undertaken, one does still have to come back, I respectfully submit, to the legal test, which is not whether the court thinks it might have been a good, bad or indifferent idea to do a bit more, but whether or not the inquiries that were undertaken and the nature of the issues that were considered in the report itself, and to some extent the nature of the presentation of the issues to ministers, was such that no rational decision maker could have reached those conclusions, could have presented it in that way without undertaking the further inquiries necessary to produce the material that Mrs. Justice Thornton considered was needed. So that's what we say in direct response, very briefly in relation to Mrs. Justice Thornton's judgment. Now, Lords, those were my submissions, unless I could seek to assist further.
Thank you very much, Sir James. Yes, Mr. Heavenstock.
My Lords, the first and second interested parties are respectively the operator and financier of the project. Our submissions are at core bundle page 91, and I commend those to you. You'll see from paragraph 3 of those submissions that we are staying out of the way of ground 2, the tenability debate, and we have focused on the scope 3 issue and the issue of whether the project is compatible with the Paris Agreement ground 3. I would just like to deal with a few housekeeping issues, as it were, because we've sent to you a few things during the course of this hearing, hopefully in response to some questions from the court, and due to the fact that we were probably the party with the least homework during those evenings. One of those is a note on what happens with a deadlocked or a tied divisional court. I hope you've received that with authorities. I think Sir James has seen that and agrees with its content, and in fact it replicates the submissions which were made to the court below as to what it should do as it was tied and deadlocked. So I hope that is of assistance. My learned friend Ms Simon put before the court a note on the revenue streams from the project to the government of Mozambique. We have put before you the underlying government of Mozambique document, which I also hope that you received as a bundle of further documents from us. And in that document, you will get a full description of those revenue flows. And I think the point that my learned friend is attempting to take, although I think it's one where we agree with her, is that essentially the royalties, which are a percentage of gross revenues, which are pegged to the spot Brent oil price, as you would imagine, we don't have to convey a high percentage of those to the government of Mozambique until 2030, because of course we have taken the burden of actually funding and borrowing money to produce the project. And so there is a cost recovery mechanism, which means that those revenues do not begin to ramp up until 2030. Now, of course, those revenues were all based, this is all based on work done in 2018. And to give you a flavour, those projections are done on the basis that the Brent oil price today would be around $65. It is, in fact, as we all know, due to the events that are going on in other parts of the world, now clearing $70 or $80 a barrel. So should this project come on stream, and should the geopolitical situation not have changed, obviously the revenues which will go to the government of Mozambique will be even higher than projected. So we provide you that so you can see the underlying government of Mozambique position. The senior president asked about the definition of developing parties to the treaties, and we've tried to answer that as best we can using an extract from another textbook on the Paris Agreement, a commentary by Gert van Kalster and Leonie Rains. And I would just, if you can find that small bundle of things that came up from us last night, if you can find that extract which we have hopefully paginated, it is just worth dwelling briefly on those extracts, because you will see at internal page 46 of that book, IPB page 3, at paragraph 1.29, it's actually recorded that there was going to be some definitions in the Paris Agreement, in the draft, but actually they didn't appear. It was that you can imagine that it would be controversial as to who might be developed or developing. Although there has been, as when you turn over the page and you just run through those paragraphs, you see that, and I think my learned friend Miss Simon mentioned this, in previous treaties there had been a divide between the industrialised members of the OECD, developed parties, and the rest of the world who were classified as developing parties. And as the learned authors conclude, it says at paragraph 1.30, at best, it can be assumed that the Paris Agreement implicitly follows that list approach. You will also see...
There's no question about that Mozambique as a developing country.
Well, I'm just about to turn to Mozambique.
You are?
Because if you look at paragraph 1.31, you will see that it says, on occasion, in line with the convention, so that the convention is the UNFCCC, the agreement further divides the developing countries group into LDCs and small island developing states. And if you run down that paragraph, you'll see there's no definition, but at the end of that paragraph it says, this term is most plausibly to be interpreted by reference to the list of LDCs recognised by the United Nations General Assembly. Footnote 98 gives you a list, and at the end of this extract you have the list, and Mozambique has been an LDC since 1988. And then you ask, what is the significance of that? And if you turn over the page, this is another extract from this textbook, paragraph 4.20, and this is a provision of Paris that my learned friend did not read to you. It's Article 4.6. This recognises the specific situation of Mozambique as an LDC and the islands on the grounds of their limited capabilities and possibly their disproportionate exposure and vulnerability to the impacts of climate change. Accordingly, these states are authorised to prepare strategies, plans and actions for low GHG emissions development reflecting their special circumstances. this provision may be construed, and I think the may be construed is illustrative of all the academic commentary that I've seen on the Paris Agreement, may be construed as implicitly exempting LDCs from the recommendation, it's an interesting word to use, recommendation, contained in Article 4.4, that developing countries move over time towards economy-wide emission reduction or limitation targets. So these authors are positing, tentatively, because we're all struggling to understand the words of the agreement, that 4.6 is in fact an exemption from the obligation on the developing, not developed, developing parties under 4.4. Although, in fairness, it goes on to say it could also be viewed as excluding LDCs and SIDS from the expectation expressed in 4.3 that the NDC would reflect its highest possible ambition, yet 4.6 does not expressly or necessarily imply an exemption from the procedural obligation to prepare, communicate and maintain. And in fact, as you've seen from Sir James, Mozambique has in fact produced an NDC, and therefore clearly Mozambique does not consider itself exempt from the obligation to produce an NDC, but it is suggested that 4.6 is an exemption from moving over time towards emission reduction or limitation targets, simply because of the parlous state that Mozambique finds itself, as we all know from the evidence in this case. So that's dealing with definitions. I also would just like, I'm afraid, to just dwell, if I might, on page 355 of the supplementary bundle. This was the, I think it's been described as a back of an envelope calculation of the Scope 3 emissions. And when I heard my learned friend deal with this in her submissions, and when I went back to the transcript last night, I'm afraid that what she said was not accurate. She said that the top line, the A, is, and the transcript says, this is just Scope 1 and 2. That is not from the liquid natural gas. That is from the actual production facility. And then you get overall emissions on Scope 3. And then she says, you see the 805.75. If you add that to the 12.88 multiplied by 25, you get a sum around 1.12 gigatons. Now, that's not what this is saying. The 12.88, and you'll see that number throughout these papers, and I'm going to go to it during my submissions, that is the production from 2 trains liquefying and processing liquid natural gas. So 12.88 megatons per annum is the amount of gas that the project will produce from 2 trains. You times that by 25 years to get 322. And then you, as you can see from the following paragraph, you apply some values that you take, not from the Duke's methodology, but from the digest of the United Kingdom Energy Statistics, which is known as Duke's. And those values give you the 0.184 kilogram per kilowatt. You then do some maths, and you can see it played out here, to turn your 322 megatons of gas into oil equivalent. You then turn that into kilowatts. You then apply the 0.184 kilograms of carbon per kilowatt of oil equivalent to get your 805.75. So it's pure maths. It's taking that key value from the Duke's depository of the 0.184 kilowatt for natural gas, and then working out how much carbon you have in the liquid natural gas that's going to come from the 2 trains in northern Mozambique producing 12.88 megatons per annum. So that's how that very simple way of working out Scope 3 works.
That's clearly an absolute figure.
Yes.
On an average rate of combustion, if that's the right concept.
Yes, it assumes it's all going to be combusted, and all that carbon dioxide will be emitted.
Yeah. It's to that extent, could be described as a raw analysis.
Indeed, and I think it's been described as as an overestimate, because as it says there, we've assumed that my client's LNG capacity is going to be maximum of 25 years. Well, that would be extraordinary, as good as my clients are at building LNG facilities. Whereas in reality, it will be closer to 90%. As such, these numbers should be considered very rough and are for internal reference only. Apart from, I don't know if I'm referring to a Duke's methodology, she also, as you've seen, has referred very much to the GHG protocol methodology. And I can commend to you, without turning to it, paragraph 37 of our skeleton, core bundle page 105, where, and I think that UKEF agree, that this protocol is used as an accounting process. It's not a predictive protocol. It's a way of telling the world, and there are, as you know, various reporting and accounting standards which companies have to comply with, not least my clients. It's a way of telling the world how much your business has produced in scopes 1, 2, and 3 in the past. And it is worth just dwelling on the fact, and we draw this out at paragraphs 38 and 39 of our skeleton, which again I commend to you, and it's something that Sir James mentioned as well, that scope 3 emissions are merely an intellectual construct, and they are in a way passed around the world, because the scope 3 emissions from this project, if they're going to be burnt in India, they're somebody else's scope 1, scope 2. If it generates power that then goes on to turn into steel or products, they're somebody else's, some other company or some other country is reporting them as scope 1, scope 2 or scope 3. And really what is said in the next paragraph on this page, when this town says, but ultimately it should be noted that LNG investments and supply will continue to grow until demand is abated. As such, scope 3 emissions will come from this project or another, is entirely true. The control on these scope 3 emissions from the project being developed by my clients and others is in the NDCs of the sovereign states in which they will be combusted. That's the control.
I mean, can I ask why that matters, this analysis?
Well, it matters, my lord, because one has to take into account the way in which the scope 3 emissions from this project are already priced in, if you like, to the world's response to climate change through the NEDCs of a wide range of countries and a wide range of plans and processes put forward by companies all around the world. The point being made here, which is that
may be the case, but that's only the case if some other fuel is reduced. The use of some other fuel is reduced. But if you're adding globally to the amount of fossil fuels burned, then it's not already priced in.
Well, NDCs, as you will see, are forward-looking by many decades. So countries are promising to reduce emissions by a certain quantity over many decades. Therefore, for my scope 3 emissions from the project to be accommodated in other countries' NDCs, for the next 25 years of the life of this project, that all already has to some extent being done.
Well, it can happen, or it may not happen. But I mean, the truth is, that's not really the issue in this case.
Well, it goes to the importance of the scope 3 analysis, because what is being said here.
You say it's not important.
Well, I don't say it's not important, my lord. That would be driving into two extreme positions.
Can I suggest an answer to this question, which may or may not commend itself to you? That is that there is here an assumption that there will be 25 years of production, which will be effective production in the sense that the LNG produced will be bought and used, largely by other countries or in other countries. That is the starting assumption.
Yes.
Over that 25 years, many things may happen in the world, including in the hardening of COP commitments to reduction measures and targets and obligations. But this analysis is a raw analysis which assumes that all of that LNG liquefied and burnt will be burnt at the rate assumed. And on that basis, I'm not saying it's a worst case analysis, but that is the basic assumption underlying this. It doesn't account for any other change, any other variable in the global consumption of fossil fuels.
I entirely agree, my lord, and I will come to those nuances and variables in due course. But I entirely agree. This is the raw absolute figure. What happens next in the geopolitical play is another matter entirely. And as we know, the world has turned a few times since even this case was before the divisional court. But just on this point of this paragraph, because the writer of the email goes on to say, the most important way of comparing is through Scope 1 and 2 emissions compared to other LNG projects. Estimates from consultants suggest this will be one of the lower carbon LNG producers globally, in addition to providing incomes to one of the poorest nations in the world. So just ignoring that last sentence for the moment, although it's an important point, you will find what he's talking about at supplementary bundle 247, where Wood Mackenzie compare the Scope 1 and 2 emissions of this project against some competitor LNG projects and find them favourable. This is not least because, and this is picking up on something I think Malone Feminist Simon said, that methane escapage or fugitive methane, to use the jargon in the industry, is of great concern and importance. And this project has gone to great lengths to ensure that there isn't, or that the methane escapage or fugitive methane is kept to the lowest level possible, which is one of the reasons why it has some of the best Scope 1 and Scope 2 emissions compared to its comparators. The senior president also asked about EIAs or ESIAs, and the then managing director of the first interested party provided a witness statement to the divisional court, which appears at page, or the material paragraphs appear at page 554 to 556, paragraphs 38 to 42, and you'll find a lot of information there about the other EIAs were done. Obviously, you will have picked up that quite apart from climate change, there are many other environmental and social risks attached to this policy. You'll also have picked up that the government of Mozambique, the World Bank, the IMF, the African Development Bank, and the other ECAs, many of whom, of course, are parties to Paris, all of them had to be satisfied that all the relevant international legal standards, including those set out in the International Finance Corporation's performance standards, all of which you will find set out in great detail should you be interested in our summary and detailed grounds, all had to be satisfied, and all were satisfied. And you will find all that detail, which includes matters that my learned friend mentioned, such as, can we make sure that if the seas rise in Mozambique, or if there is another storm, catastrophic storm in Mozambique, can these assets stand those tests? So can they stand the tests of climate change in Mozambique? All of that had to be tested. Whole populations, as you've seen, have been displaced. Bird life has had to be catered for, as has marine life, as you would expect of a project of this size. And all of that has been done to the satisfaction of the government of Mozambique, and also to this various lenders and international financing institutions.
Sorry, Mr. Hebbleton, what do the lenders have to be satisfied of?
So there are various standards set out by a partner to the World Bank called the International Finance Corporation. And they have a whole catalogue of standards called performance standards, and they relate to human rights, the social impact, the environmental impact. And an organisation called RENA, well known on the stage, produced an impact assessment that addressed all of these questions. That is a different impact assessment to the one that UKEF, operating independently under the OECD Common Approach, has produced for itself. the one I'm talking about, belongs to the project. If you are interested in details about the project itself, our summary grounds at 460 of the core bundle and detailed grounds at 380 are replete with information, if not also photographs, including maps and what an LNG train actually looks like. And one of the things that you will find in there is a graph at page 395.
So which page is that you referred to?
The grounds, the summary grounds are 460, the detailed grounds 380, map at 385, picture of what their project looks like is at 385, and then there's a graph at 395, core bundle. And I only mention this because there's been a lot of passing reference to the IEA. The IEA is the International Energy Agency. It is concerned, and has been since the oil crisis of the 1970s, with energy security. It's a treaty organisation that sits within the OECD. You will see more on this at paragraph 60 of our detailed grounds. And the graph at 395 is from something called the SDS, the Sustainable Development Scenarios. And you've probably seen in the documents people at UCAF and other places saying that this project fits within the SDS. And that in 2019 was the IEA's best guess of the energy mix going forward, that includes a small, moderate rise in LNG. But what I do think is interesting to note, because time and policy and scientific views does move on, is that you'll be aware that there was expert evidence before the divisional court from the appellants and also from us interested party. And you'll note that Lord Justice Stuart-Smith notes that it wasn't really put before the divisional court because the court was expected to consider it or rule on it or try it or anything like that. From my client's perspective, it was put there to show that there are a range of reasonable opinions on all of these questions, differently held by highly qualified scientists who reasonably disagree. And our expert is Professor Hawkes from Imperial College, and in his report, and I'll just give you the reference, supplementary bundle, page 527, he notes that the IEA itself, by May 2021, had moved on. And at paragraphs 11 and 12 of that report, he notes that the IEA were now saying that whilst the projects in the oil and gas world, whilst the fields which were being opened could be opened, so the project we're concerned with is safe, the IEA was saying that there ought to be no further new LNG facilities. So that's just to show you that an organisation, a treaty organisation that I think many people see as coming from the perspective of the OECD and the developed industrial nations, between 2019 and 2021, had changed its own predictions and guidance on what aligns with a Paris-compliant scenario. Now, it's not for me, and I don't link that to the change in government policy that you've heard about, but it's just to show that science and policy and geopolitics are constantly on the move in this area. It cannot be a hard-edged legal question as to what is or what is not compliant with Paris. It is a multifactorial, scientific game of four-dimensional chess, taking into account conflict, energy demand, geopolitics, demand from China, demand from India, growing populations. All these factors have to be brought into account before you can begin to build those shaded grey pathways that my learned friend took you to. And the UN has done them, the IEA has done them, my own clients have to do them. How are we going to get to net zero? What is the pathway? And those pathways are not static over time. They can change. Government policy can change for a wide number of reasons. My own client's positions and its future plans have to change depending on the market, depending on politics. So it's interesting to see the IEA going about its business in that way. And then the other organisation I want to touch upon a little bit more than you've already heard from the other parties is the position of the African Development Bank. Again, this is another treaty body. It's been around since 1963. The United Kingdom's been a member since 1983. And you'll see that from Mr. Taylor's witness statement, paragraph 61, supplementary bundle 472, at the time of this decision, the United Kingdom shared a board seat of the AFDB with the Kingdom of the Netherlands and Italy. They rotate, and it happened to be the civil servant from DFID who was in the chair on the day that the AFDB took its decision. And as Mr. Taylor confirms, he voted on instructions from DFID in favour of the $400 million senior loan that's gone from the AFDB to the project. And it is just a reminder of precisely what is in front of this court, because as we were reflecting just before the short adjournment, what is before this court is UKEF's decision to support what Lord Justice Stuart-Smith records as, at 165 of his judgment, in excess of £1 billion worth of UK content contracts from what he, using his words, specifically for hard-pressed industry in Scotland and the north of England. So that is UK's statutory focus, the 2,000 jobs in Scotland and northern England, which are going to provide services and goods to the project. And that's quite apart from aid decisions or international development decisions, such as the one taken to support the AFDB's provision of $400 million of assistance. It's a different focus. Now, can I turn to the African Development Bank board report, because it is an extraordinarily convenient way of getting through a large amount of material, and it's at supplementary bundle 121. And if you get to that page, you'll see what they were looking at a memorandum that was submitted to the board of directors of the African Development Bank on the 15th, or the date of presentation is the 15th of July 2019. I think the date of the document is the 2nd of July. And the question the board is considering is whether to give a senior loan, i.e. one that will have priority in terms of recovery and securitisation over the others, of $400 million. And you'll see that there's a summary and some boxes that we don't need to worry about, although that is preceded by I find anyway, a very useful list of abbreviations. There's a introduction, and at paragraph 1.5, you set out how the bank's team have collected and analysed all the information in order to make this report and these recommendations. You then, as I promised before, at 2.1, get my figure of 12.88 megatons from the two trains. You can see that 12.88 is the megatons per year of LNG. It's definitely not scope 1 and scope 2. You get a description of the concession itself, and you'll notice that we're concerned with Area 1. There is another concession, Area 4, that is going to be developed by other companies. This court's only concerned with Area 1. You'll see in 2.3 that my clients are not mentioned in 2.3 because at this time they were not part of the consortia that was going forward. We'll come to my clients in a moment. And at 2.4, I'd just like to note that the government of Mozambique does not just have access to the royalties, taxes and revenues, but also has a 15% share, which the project is required to carry, using the language of that paragraph, through ENH, which is its nationalised gas company. Long description there about the project. 2.8 gives you the project rationale and uses the transformative language that you have seen in other documents, which I will not repeat. The second interested party is mentioned briefly at 2.9, the borrower and so forth. And you will see as you run through the paragraphs in 131 and 132, particularly at 2.14, you'll see that Total has, through mergers and acquisitions, obtained an interest in the main operator, which was Andanaco. Total are the successors to Andanaco, and you see that in 2.14. You can see the enormous cost of the project in 2.15, 25.4 US billion dollars. And you also see in a table above 2.17 how the project has been financially structured, and you are concerned with some of that direct and covered support from UKEF, which is just one of the many ECAs providing support just under the senior debt at the top half of that table. Then comes AFDB, and then just to correct any misapprehension that you might have from some of the submissions of my learned friend, commercial banks are invested and providing support to the tune of 3.5%, and then obviously that all adds up to 100%. So that is information about how the financing of the project is structured. You'll see at 2.33 2.23, how the bank was also supporting Mozambique, not just with this project, but lots of other related things in the same area, not least agro-business and agro-processing. Because one of the things that you can do with the gas is turn it into fertilizer. And one of the things that Mozambique really needs is fertilizer, which, as you know, has become extremely expensive because of the price of liquid natural gas. And all developing countries need that fertilizer to provide food security. You'll also see that there's various roads and other investment, as you'd expect, in and around the project. Now, time being short, I will leave you to peruse this document in what has been referred to as your spare time during this hearing. You'll see at paragraph 2.42, page 137, a summary of the government of Mozambique's timely support towards the implementation of the project. And in order for that support to go ahead, the IMF and the World Bank had to give their approval because, of course, Mozambique has experienced debt problems in the past. In fact, my learned friend alluded to that position. And the World Bank had to take quite an exceptional decision to allow this project to go ahead because of Mozambique's position. But my learned friend Sir James took you to the World Bank's document where it was explaining why it was prepared to take what would otherwise be a risky and exceptional decision. You've heard mention of domestic use of gas. You can read all about that in 2.43, and I think it's in 2.43 that the key fertilizer project is mentioned. 2.47, another graph for you about the demand for LNG going forward. I would just note the footnote there, footnote 7 at the bottom of page 138, and note that Wood Mackenzie is described as the lender's market advisor. You probably picked up from the proceedings below that there was some confusion about whether Wood Mackenzie was an advisor to Total or not. It was the lender's market advisor, and it's in that role and that role alone that they are commissioned by UKEF to provide the document that you have seen. So lots of information there, and then you will see at 2.53 the opportunities, the key opportunities that will arise from this project. And they do not just include sending the LNG off far and wide to Asia or to Europe. They also include at the bottom of that paragraph that South Africa does not have any gas-producing assets. Of course, South Africa is a bigger country than Mozambique, with more population and more sophistication and more energy needs, but is currently addicted to coal, and the gas from Mozambique can very much help South Africa, its very close neighbour, be weaned off that coal for the reasons that we all are aware of. Jumping ahead to paragraph 3.24, not only at page 144, not only will this project be transformative in terms of revenue, it will also be transformative in terms of GDP. And the reason for all of that, and it is an extraordinary contribution to GDP, you'll see that in the analysis from PricewaterhouseCoopers in the table that follows, is because of the paragraphs which follow, which, as you expect, are about jobs and skills. The project will support 5,000 Mozambicans into work. It has the potential to create 44,000 jobs indirectly. And you'll see that that all has an incredible effect on household income, government revenues, SMEs, and the report also goes on to consider the effect on gender rights and other rights and circumstances of the population of Mozambique. There are paragraphs on climate change and paragraphs on environmental effects, as you'd expect. Gender is at 3.35, social effects 3.36. And all of that comes to the commending conclusion at paragraph 4 on page 149, which leads, as we know, to the bank, commending this project to the board, who obviously, as we know, votes in favour. I should just draw to the attention of the court supplementary bundle page 552 and paragraph 31, because you may have seen in some of the ministerial submissions there is concern that the project is facing security issues. And Monsieur Bescond, who is the managing director, or was the managing director of the first interested party, at paragraph 31, sets out the concerning state of the project vis-à-vis the security situation in northern Mozambique. And I can confirm to the court that at the present time, that is the status of the project. It is in force majeure because of what you'll have no doubt seen in the news and so forth, the serious security situation in northern Mozambique. So, of course, a lot of the dates and numbers that you've seen in the papers need to be pushed out and delayed because force majeure is in play in the project, because the people of northern Mozambique are facing that insurgency, and there are peacekeeping forces from various other African nations trying to restore order. So that's the African Development Bank's analysis that you have seen. I do just want to...
Is the project completely stalled, or is it going ahead partly?
I think the security situation means that Total has had to withdraw. So it is stalled.
It's stalled. Okay. Yeah. And what does that mean for the UKEF money? Has that guarantee actually taken effect?
The relevant documents have been executed. The deal has been done. You'll notice that there's quite a lot of redaction in the documents for commercial confidentiality. You will have seen, though, that obviously some of the guarantees and loans are hypothecated on the exports actually coming in and being used. I will leave you to draw your conclusions that obviously the exports need to happen for some of the commercial terms to kick in, but they are commercially confidential terms. My Lord, I said that I just want to go in the time I got to Professor Hawkes and commend some of his paragraphs of his report to you. At supplementary bundle page 521, he offers his own views on whether this project can be accommodated within the pathways from which are compatible with the Paris Agreement. And at paragraph 15, page 528, he offers his own view about whether this project could be fitted within the pathways. And he says that using that 12.88, you get to about 0.645 exajoules. Exajoules are a 10 to the power of 18, a quintillion of joules, which he thinks are about 1% of...
Sorry, where are you?
Paragraph 15, page 528, I hope. Now, the only reason for showing you this is not because I asked anybody to find that it's right, wrong, or otherwise. Someone may have to check with the 528 wrong. Let's have a look. It's paragraph 15 of his report. It's maybe the 528 that's misleading. 539, thank you. It's just to show, and I'm sure that my learned friend and her clients fundamentally disagree, but it's just to show that there is a world, there are experts, professors of Imperial College London, who consider the project fit within compliant scenarios. And one of the reasons for that is because of the width of those grey bands on my learned friend's graph. There are lots of scenarios, and he says quite a few of them include LNG and continued LNG use. Some of them don't. Some of them are overshoot. The idea that you can construe the Paris Agreement and say it binds you to a pathway is not sustainable, because there are lots of pathways, lots and lots of them, as you saw. And then on scope 3 emissions, going on into his report at paragraphs, I'm going to stick to paragraphs for a minute, my numbers seem unsound, but 39, 40 onwards to 43, and I commend those to you, 39 to 43, he essentially picks up on what the senior president was, the point that the senior president put to me, which is that essentially lots of different things can happen. And the scope 3 emissions could be frankly horrendous because the LNG replaces green energy, something we really don't want to happen. Or the LNG replaces very dirty electricity generation without any carbon capture technology. This is at 38A. And you end up with very large amounts of scope 3 emissions. Because it all depends on what happens next, where it's used, what technology is deployed. And he ends up with different figures for scope 3, taking into account these avoided emissions, which are sort of 700 times apart in scope. And that's because it all depends. And that's why he comes down at paragraph 43, although you may think it's not for him to express this opinion. But he comes down in paragraph 43 to say that he finds the CCR reasonable because it's the best thing you can do given that you're playing four-dimensional chess in a very uncertain world. We don't know what technologies are coming. We don't know what the gas is going to replace. So I merely commend that to you as an example of a reasonable view. Lots of people have already taken you to the United Nations Convention and the Paris Agreement. We entirely agree with the submissions of my learned friend, Mr. James. We commend to you the judgment of Lord Justice Stuart-Smith. The golden thread in that judgment are all, is the now well-established notion of common but differentiated responsibility. And you'll find yet another extract from yet another textbook from Philip Sands in the Authorities Bundle, which traces the development of that concept from the more perhaps familiar concept of equity. And in fact, equity, as I think the Master of the Rolls noted, finds its way into the treaty. And Lord Justice Stuart-Smith noted that if my learned friend's submissions were taken to a certain level, I'm not going to say extreme, but to a certain level, you do end up in the rather interesting or alarming situation whereby the global north is saying to the global south, we have had the benefit of fossil fuels, but you under Paris cannot. And I think in our skeleton argument, we adopted some words from the Tony Blair Institute and referred to this as kicking away or pulling up the ladder, which my learned friend in her skeleton argument in response described as offensive. But actually, it is a sentiment expressed by Lord Justice Stuart-Smith in his judgment when he talks about the unfairness that can result from that sort of situation. And in fact, one of the most interesting recitals of the UN Convention, it's I think it's the 21st, it's at the top of page 14 in our bundle. I don't need to turn it up, but it's that it affirms that responses to climate change should be coordinated with social and economic development in an integrated manner with a view to avoiding adverse impacts on the latter, taking into full account legitimate priority needs of developing countries for the achievement of sustained economic growth and the eradication of poverty. So you have to avoid the adverse impacts on social and economic development which might come about from the responses to climate change. You have to watch for the unintended consequence of driving a country further into poverty because of your response to climate change. That is the inherent policy tension, geopolitical tension, at the heart of the Paris Agreement. And it's why Lord Justice Stuart-Smith comes out with where he is on the treaty, because you do have these irreconcilable problems at the heart of the Paris Agreement. And then, how do you look at the Paris Agreement and then come to assess and decide whether a project such as the present is in alignment with it? And my only submission is that cannot be a hard-edged legal question and answer. It is as I entirely agree with what my learned friend Sir James Eade said, it is entirely a multifactorial, very difficult, very complicated political judgment and assessment. It cannot be transmuted into it's either lawful or it's unlawful. Paris cannot be construed in that way. And as I say, I'm not going to take you through them. You have seen in the recitals and the articles of Paris that it is suffused throughout with words such as the temperature goals are in the context of sustainable development and efforts to eradicate poverty. It's Article 2.2 that expressly references equity and common but differentiated responsibilities. I've already shown you that for a country such as Mozambique, it has a very different obligation in Article 4.6 that is not even as onerous as that on other developing countries. So it's very clear to us as to why Lord Justice Stuart-Smith came to the conclusions that he sets out in his little Roman numerals at paragraph 225 of the judgment, in the way in which he examined and set out the way in which the Paris Agreement worked. It is right, my lords, in conclusion, to remember the words that are actually in the master plan that the government of Mozambique has put forward. And you'll have seen from James's submissions that the government of Mozambique, through that master plan, has said that this project, Area 1, is integrated and part and parcel of its efforts to reduce emissions. Now, as apparently counterintuitive as that might sound, that is because, as Lord Justice Stuart-Smith mentions in his judgment, he didn't receive any evidence about any alternatives, some other project, some other investment in solar or wind or hydroelectric that is going to come to Mozambique's aid to give it the revenue to raise its seawalls, to prepare for cyclones, to prepare for the effect of climate change, to build an electricity grid, and to transition, as we hope all countries can in the end, to green energy. And that's what the master plan says. The master plan says at supplementary page 44 that the government of Mozambique wants to use these resources, the gas, in such a way that they can contribute to the country's socio-economic development, while at the same time preserving the environment and ensuring enough resources for future generations to fulfill their energy needs and to develop their country. And ultimately, that's that sovereign government's political judgment that this sovereign government, represented to the right to me, is quite entitled, under Paris, to support, to finance, and facilitate. So for all those reasons, we invite you to dismiss the appeal.
Thank you very much. Yes, Ms. Sam.
My Lords, I'm going to start with two logical flaws with the tenability standard, and then I'm going to address Sir James's tour of the authorities. The first logical flaw, then, the respondents say that the question for this court is whether the decision maker took a tenable view of the UK's obligations under an unincorporated treaty. Question then, what view did the decision maker take of the UK's obligations under the Paris Agreement, in this case, in June 2020? Answer, we don't know. We don't know because it's legally privileged. It's been redacted. In fact, this morning you received the correspondence handed up with Lee Day, and between Lee Day and the government, the letters dated the 24th of September 2021. And the short of it is, the appellants asked, tell us what your tenable view is, and the responsibles will know. We can't tell you what that view is, legally privileged. So whose view then is going to be judged to be tenable by this court? Is it going to be Sir James's view that he expressed this morning? Now that view may have been very different to the view that was expressed in the lower court, and it's unlikely that it was the view that was taken by the decision maker. So can this court say that a view articulated by the Respondents' Council today is tenable, so that the decision taken in June 2020 was also tenable, whether or not that was actually the view taken by the decision maker? Now, my Lords, the answer is yes, of course you can, so long as we agree that we're talking about a question of law. You recall that Sir James said yesterday that the issue of the compatibility of the Paris Agreement should not be treated as law, but instead should be treated as any other relevant factual consideration. And he said that we were committing a category error by treating it as a question of law. But if it's not to be treated as a question of law, then it clearly follows that no legal privilege should attach to it. No legal privilege should attach to the legal reasoning behind the government's decision. And it would be imperative to have the government's legal advice on these non-legal matters on St. James's submission, because they would be the reasons that would supply the predicate for any challenge to a factual consideration based upon rationality. It would also mean,
my lords, that everything that Sir James said about the Paris Agreement today would be inadmissible evidence, because he would be, in effect, testifying on behalf of the Secretary of State as to what his view of the Paris Agreement was, as a matter of fact. But if we return to reality and treat this as a question of law, then everything makes sense. Yes, of course legal privilege attaches to the reasons. And the law applicable to the decision at the time of the decision in June 2020 is the same as the law applicable today. So if Sir James convinced you today that the decision was compatible with the Paris Agreement, then the government wins. And the government would win even if they actually decided the question by flipping a coin in June 2020 without seeking legal advice at all. But that only works if we treat it as a question of law. And if we treat it as a question of law, the review is based on error of law. As I say, if we're talking about a tenable view of a factual material circumstance that can only be challenged against a rationality standard, then we're entitled to say that no view of the interpretation of the Paris Agreement was expressed in June 2020. And a non-existent view can't be a tenable view. And again, Sir James submitted yesterday that we committed a category error by characterising the issue as one of law. But if we treat it as just another relevant consideration, then we're left with a bare assertion in June 2020 that the decision is compatible with the Paris Agreement. And a bare factual assertion can't be a tenable view of the United Kingdom's obligations under the Paris Agreement. So, what cannot be right is to treat the issue as a legal issue for claiming privilege, and a legal issue in terms of counsel entitled to make submissions upon it and attribute that legal view to the decision maker in June 2020, but then say, well, for the purposes of defining the threshold for the standard of review, it should be treated as a question of fact, just another garden variety relevant consideration. That would be at best schizophrenic. That's the first logical flaw with going down this tenability path. The second one is that tenability actually gets you to the same place as non-justiciability. We want to be very clear about this. It's not a standard of review. It results in no review. And this is not surprising, my lords, because all the factors that are cited by the respondents to justify a tenability standard are drawn from Lord Brown's speech in Corner House Research, which of course concerned justiciability and was obiter. I'll come back to that. Now, justiciability in this case has been conceded. But the respondent's case before you is that this court should end up in the same place as if the issue were not justiciable, except that we're going to go via the route of tenability. And you can see this play out in the judgment below. Perhaps we should take it up again. And this is, again, tab 11 of the core bundle. I won't spend too much time on it because I know your lords are very familiar with it by now, but if we go to page 155, and we see at paragraphs 121 to 124 of the judgment, this is where Lord Justice Stuart-Smith applies the four factors identified by Lord Brown. And so he says at paragraph 121, the language of the agreement is aspirational and highly political. He says at 122, the different objectives of the Paris Agreement are in opposition to one another. 123, no established jurisprudence. And 124, the court's not authorised to decide questions so as to bind the near 200 sovereign parties to the Paris Agreement. Of course, as a matter of law, that is incorrect. But then if we go to how this all plays out when he comes to decide the question.
Are you saying that the decision of this court binds the 200 parties?
No, my lord, I'm saying it's not a relevant factor because clearly it doesn't.
Right.
If we go to 189 of the bundle, and this is where it all comes out.
Sorry, 189 of which bundle?
We're still in the judgment, my lord.
I didn't
And
use
we're
the bundle.
paragraph 230.
Thank you.
And he says this: I've already referred to the need for caution in approaching the interpretation of the Paris Agreement. The words of Lord Brown ring loud and clear. In the present case, the court is being asked to consider deep and difficult questions of construction that are of profound importance to the whole working of the Convention, without the benefit of any established Convention jurisprudence. The case does not fall within the categories of case identified by Lord Sumption in Venkerbusch as being cases where the court is bound to supply an ascertainable answer. Accordingly, I do not attempt or purport to give a definitive interpretation of the provisions of the Paris Agreement to which we are being referred or their legal effect. Now, just pausing there, that is an incorrect, in our submission, interpretation of Lord Sumption's speech. Lord Sumption did not identify categories of cases where the court is bound to supply an ascertainable answer. My lords, he said rather that the court is bound to supply an answer to a justiciable question of international law, and that Lord Brown's speech illustrated a possible exception, but certainly not the rule. And Sir James correctly pointed out yesterday that Lord Sumption's consistent position has been that if the question is justiciable, it must be answered by the court. And the senior president asked yesterday whether Venkerbusch is relevant at all to questions of international treaty law, and the answer is yes. It was a general statement of principle. And if it weren't, he wouldn't have referred to Lord Brown's speech at all in Corner House, because that case had nothing to do with customary international law. Now, the judge below, Lord Justice Stuart-Smith, does not interpret the Paris Agreement in accordance with the mandatory approach of the Vienna Convention, and then assess whether the government's view of the Paris Agreement deviated from that interpretation to an acceptable degree to remain tenable. That is not the exercise he embarked upon. And indeed, Sir James this morning accepted that one has to approach the Paris Agreement through the lens of the Vienna Convention. So what does Lord Justice Stuart-Smith actually do? What he does, my lords, is that he takes his rationale for refusing to interpret the Paris Agreement and then measures the government's decision against that rationale. He takes the rationale for refusing to accept an interpretation or the necessity to interpret the Paris Agreement, and he measures the government's decision against that rationale. And we see that in the very next paragraph, paragraph 231. And your lordships are familiar with the language. He says, the second sentence or third sentence, once the Paris Agreement is approached on the basis that it does not give rise to hard-edged freestanding obligations, but should be seen as a composite package of aims and aspirations that may be, and in this case are, in tension or frankly irreconcilable, UKEF's approach, which involved recognition of those conflicting aims and aspirations, and an evaluative balancing exercise in order to come to a conclusion, cannot be criticised.
So, I mean, I don't know if you're coming to this, Mr. Douglas, but I mean, if the court were to take the view that Sir James sort of advanced with some encouragement from me as to the actual construction of the Paris Agreement, how does that affect your argument?
My lords, you would have to test that view against the view that you come to the Paris Agreement by applying the Vienna Convention, and you would have to decide whether or not that view is correct.
Well, if that view is correct, how does it affect your argument? So if Article 2 is the purpose, and Articles 4, 9, etc. are the obligations, so that passage you've just read us is wrong. How does that affect your argument?
My lord, if Article 2 has no meaning at all in the sense of
No,
imposing...
I've just told you what
No, I understand, but...
If it's the purpose of the agreement, but not a hard-edged...
But it doesn't give rise to an obligation. No, what I was
the
about to say...
obligations are in 4, 5, 6, 9, whatever.
Well, our answer to that is that's an incorrect interpretation.
You say that's wrong. Okay.
And you may have noticed
But I mean, therefore, if it's not wrong, if the court decides it's not wrong, that's the end of your case.
Absolutely. But we're talking...
For a different reason than that given by Lord Justice Stuart-Smith and Mrs. Justice Thornton.
We are more than happy to fight this out on the battlefield of the law, my lords. And that involves coming to a view, a legal interpretation of what the correct interpretation of the Paris Agreement is. And we say it's highly relevant that when Lord Justice Bean asked Sir James this morning, so what interpretation would you give to Article 2? He was not able to answer that question. The way he answered that question, say, well, I can tell you what it doesn't mean.
I mean,
but that's not
I'm
providing
sorry,
an effective interpretation.
But I'd forgotten. I asked Sir James what the category error was. I've looked back over my notes, and unfortunately, I wrote it down under some different heading, and I can't, by searching, find it. You say that he said the decision they were taking was a factual one?
My lord, what he wants to say is that the tenable view, the government took into account the Paris Agreement as a material relevant circumstance.
Yes, and took a tenable view that financing a fossil fuel project overseas was not a breach of the Paris Agreement. The view, then, is as to the legal question of whether it was a breach of the Paris Agreement.
And in our submission, in order to test the tenability of that view, the court has to arrive...
No, I know you say that. I mean, what I'm putting to you is that the submission that he said was all a question of fact, and he's refused to disclose the legal advice he got on grounds of privilege, which is a bad thing to do, is not what happened. He has refused to give his legal advice, which he's entitled to do, and he submits to me, forgive me, he submits to us that the government took a tenable view as to the legal question of whether this was banned by the Paris Agreement.
He submits to you as a matter of law that it was a tenable view. And that contradicts his submission that we're committing a category error by treating it as a question of law. And his submission...
I just don't... I mean, I'm sorry, you can say it 3 times, but I still don't understand it.
Because, my lord, the respondent's position in this case is that by virtue of Lord Brown's factors in Corner House research, you should not interpret this treaty. That is their case.
I accept that, but that's a separate...
Well, I hope you don't accept that, my lord.
No, I accept that's what they said, but I don't... I accept that he says that we should not interpret the treaty because we can't. But he does say that we can nonetheless accept that they took a tenable view as to the meaning of the treaty.
And what I say...
Without saying, and to my mind it's perfectly feasible to say that is a tenable view of the construction. We don't know what the proper construction is, or we don't need to decide the proper construction, which, by the way, Lord Justice Stuart-Smith did say.
My lord, in our submission, those two things are irreconcilable. You can't test whether their view is tenable, so long as we're clear that we're talking about the law, we're talking about a legal issue. One cannot test the tenability of a view unless one has a benchmark. And that benchmark comes from interpreting the treaty. And their whole case is, you can't interpret the treaty.
Why can't I say, I don't know what the treaty does mean, but I know what it doesn't mean?
My lord, that's not a tenable view.
The category error, for what it's worth, is engaged with at the foot of page 140 of yesterday's transcript.
It's in the skeleton too, my lord.
Yeah, but the exchanges to which my lord the Master of the Rolls is referring occur there or thereabouts. And Sir James is recorded as saying the reason it is a category error is because those two things, domestic law and unincorporated error, what it's recorded as being, CSC, are constitutionally different. They're different in terms of the court's role and they're different in terms of the executive's role.
Which is not what you've just said, Mr. Douglas.
My Lord, we'll find the passage in the Skelton argument, and obviously Sir James will correct me. But the thrust of this argument is that we should not be treating this issue as one of law. We should be treating it as a relevant material circumstance, which can only be challenged on the basis of rationale. And that requires you to find that we're not treating this as an error of law. That is what we understand the submission to be.
Well, okay.
And going back to the passage that I just read from the judgment, we would submit that's not a legal benchmark against which to judge the government's view about the Paris Agreement. The conclusion there is that it's a composite package of aims and aspirations that are conflict with one another, and therefore, and I quote, the decision cannot be criticised. So there's no judicial review at all. The judge says, I'm not going to interpret it, but in any case, it's meaningless as a source of obligations, so the government's decision cannot be criticised on any basis. So this is the difficulty, my lords. You apply Lord Brown's justiciability factors that lead you to a conclusion that the treaty provisions are not suitable for interpretation by the court. So you don't interpret those treaty provisions, in which case any view asserted by the government is going to pass as tenable because there's no benchmark to judge it against. And we accept, my lords, that Lord Brown's factors could work as a test for justiciability, because if the legal issue is not justiciable, then that's the end of the matter. There will be no judicial review of that issue. But if the issue is justiciable, then it just simply makes no sense to say that the court should not come to any legal conclusion about it on the same grounds that would have made it not justiciable, and then wave through any view taken about the issue by the government as therefore tenable. So again, we say that if the issue is justiciable, then the court has to take the lens cap off the camera. And then we say you have to take a clear and accurate picture of the Paris Agreement and ask whether the respondent has provided the same picture. Now, the respondents have conceded that you have to take the lens cap off the camera, but what they submit is that they can present you with an image that's wholly out of focus and claim that it is a portrait of the Paris Agreement.
Okay, I mean, for myself, I find the analogy incredibly unhelpful because I don't understand what you're talking about with cameras and lens caps and focuses. So can we just have the argument in...
Well, the argument, my lord, is simply that if the issue is justiciable, then the court has to decide it as an issue of law.
I get that submission, yeah.
Well, I'll move on to the St James's submissions on the relevant authorities.
I mean, why is it not possible to say the issue is justiciable? In other words, it could be decided, but it doesn't have to be to decide this case because of it being inappropriate for us to decide it. All we need to decide is whether the view about it taken by Her Majesty's government was tenable.
Because it's a legal question. And you have to measure tenability against something.
Well, I mean, as Sir James submitted, it is a legal question, but it's a legal question as to the construction of an international unincorporated treaty, not a legal question as to domestic law. We do have to decide all legal questions as to domestic law if they arise, but we're not obliged to decide legal questions as to international questions of the meaning of an unincorporated treaty unless we need to decide the question of national law before the court. I mean, I said that quickly, I hope you got it.
But my lord, if the challenge is based on an error of law, and it is, because as we've made it very clear, and the respondents made it very clear, that is the premise of this decision. The premise of this decision is that it is compatible with the Paris Agreement. Now, there's a legal conclusion. We say it's wrong. They say it's tenable. Well, how do we judge whether it's tenable? We have to come to an interpretation of the Paris Agreement.
Yes, but you see, the problem is you're saying there's an error of law, and we in judicial review proceedings deal with errors of domestic law, errors of English law.
My lord,
Do not well, let me finish. We do not deal, you cannot judicially review, I don't think, I'll look around for a bit of help, but I don't think you can judicially review an error of the interpretation by itself, the error of interpretation of unincorporated international treaty, which is not part of English law. That's not my job, unless I need to decide that in order to decide some other question, whether there's been a question of a breach of English law.
my lord, that is an excellent segue into my analysis of the authorities.
Okay.
And I apologise for being old-fashioned about this, to quote one of your lordships from yesterday. But this court is bound by Launder and Keberlin. And that answers the question your lordship just posed.
Well,
The
we're
ratio...
we're bound by it if it applies to this case, but Sir James says it doesn't.
Well,
Because
Sir James declined to give you the ratio of that case. And I'll tell you what the ratio is. In those cases, my lords, the ratio is that where a minister takes a decision said to be compatible with the UK's obligations under an unincorporated treaty, then the correctness of that legal conclusion is
sorry, you've got
reviewable.
to start again. Ratio is where the UK takes a...
When a minister takes, or a decision maker takes the decision said to be compatible with the UK's obligations under an unincorporated treaty, then the correctness of that legal conclusion is reviewable by the courts. And there is no indication in those authorities, in Launder and Keberlin, that it's limited to human rights obligations. And indeed, the principle was applied in Heathrow Airport, which of course concerned the GATT. In Corner House research, neither Lord Bingham nor Lord Brown sought to confine Launder as only applicable to human rights. Indeed, the issue there was the corruption of foreign officials. Now, this is critical, my lords. In both Launder and Keberlin, the House of Lords expressly considered the constitutional principles of dualism and parliamentary sovereignty, as set out in the Tin Council cases, that form the basis of Sir James's points 1 to 4, I think they were, yesterday. And the House of Lords expressly found that judicial review on the basis that was articulated would not offend those constitutional principles. And I read you those passages on the first day. Now, my lords, no House of Lords or Supreme Court decision casts any doubt over the continuing validity of Launder and Keberlin. Indeed, in Barclay, the government accepted that it was bound by Launder to concede that there could be relief in judicial review against a decision that was taken on the basis that it was compatible with the UK's obligations under an unincorporated treaty.
Well, I mean, you say that, but Sir James showed us passages in SC.
My lord, I will get to them. I will get to them. So, in our submission, my lords, is that Sir James's points 1 to 4 would be relevant background for a challenge to Launder before the Supreme Court, but they're peripheral at best before this court, because the House of Lords in Launder and Keberlin expressly found that a judicial review was compatible with those points. Now, the respondent, as we understand it, doesn't contest the continued binding authority of Launder. What I think Sir James was saying is that if you take the pulse of recent Supreme Court decisions, then it might be that Launder has an uncertain future.
No, he didn't say that. What he said was it was confined to the particular treaty it was talking about, which was the European Convention on Human Rights, which has a very different jurisprudence from almost any other treaty in this country and elsewhere, and it was possible and sensible for this court to reach a considered conclusion on the meaning of that treaty, because we had the wherewithal to do it. And any one of the reasons why we shouldn't do it is because we don't have good jurisprudence on which to base the decision. But I mean, there's a world of difference between the Paris Agreement and the European Convention on Human Rights.
And that world of
And
difference...
that is why the cases of SC and the more recent cases, as we saw the progression, it put Launder on one side, shall we say, as a special case.
My lords, except that they didn't cite Launder. And
They did cite Launder. Each of those cases cites.
We'll get into those cases. Yeah. In those cases, had nothing to do with the minister stating that they were taking a decision incompatible with the UK's unincorporated treaty obligations. They were entirely different situations. And we'll come to those cases in a moment. But they did not cast...
I mean, I don't think the minister did state that the decision was compatible as a matter of law with the UK's obligations. What I think the minister stated was that, as I said several times on Tuesday, there's a balance here. It's not entirely clear. The position is difficult. There are risks on both sides.
My lord, we can only answer the case that's being put to us. And the case that's being put to us is that this decision was compatible with the Paris Agreement. That's paragraph 1 of the scope.
That is put to you.
So, let's go through the authorities then. We'll start with Corner House research again, and I'll make some very brief comments because we've talked about it a lot. But again, I'm being old-fashioned, but what Lord Bingham and Lord Brown said about interpreting an unincorporated treaty was strictly obiter. And it was strictly obiter because the court accepted unanimously...
Well, you said that. We know that.
Okay.
It wasn't doubted.
It
wasn't rebutted by Sir James. He didn't say
that
Lord Brown was not overturned. It's not only not overturned, it's not the majority.
I'll move on now. The next point is that neither Lord Bingham nor Lord Brown cast any doubt about the validity of Launder and Kebeline. Lord Bingham did not endorse any form of tenability review. Only Lord Brown did. And he referred, as you recall, to Sir Philip Sells's article, as he then was. But you read that article yesterday, my lords. Sir Philip proposed tenability review on the hypothesis that Launder might be extended further to circumstances where it could simply be inferred that the decision maker took into account unincorporated obligations. He did not suggest that tenability should be applied to a case within the four corners of Launder. Attention yesterday was also drawn to Lord Bingham's perverse incentives point. Now, it has to be recalled that Lord Bingham also gave the leading judgment in the Divisional Court on Kebeline that was endorsed by the House of Lords. And Lord Hope expressly endorsed Lord Bingham's point that if the advice relied upon by the decision maker was unsound, he should, in the public interest, have the opportunity to reconsider the confirmation of his consent on a sound legal basis. The court's role is to provide guidance on the law. Public officials have an interest in getting the law right, and that interest is shared by the courts. And if that interest were not shared by the courts, then, of course, the rule of law would be in tatters. Now, my lords, if in public law, if a decision maker says that he or she has simply taken into account the UK's international obligations as one of the relevant factors, then it can't be reviewed on the basis of an error of law. If, however, a decision maker says that the decision is made on the basis that it's compatible with the UK's international obligations, then it is reviewable. That statement has to mean something. And we say that the position in each scenario is completely different. The general public and Parliament are entitled to assume that when a decision maker says that a firm legal conclusion has been reached about compatibility, then that conclusion is not simply a tenable view that's impervious to meaningful challenge before any court, and there could be a different view
from the view taken by other ministers about the same obligation. And this is critical to ensuring that the mechanisms of accountability function properly. So in our submission, there can be no disincentive to take into account international obligations so long as the decision maker is transparent about the basis for the decision. What you can't do in our submission is say you've reached a firm legal conclusion and then come to the court and say that the obligations are so vague, soft-edged, and contradictory that a court of law can't interpret them. You would have noticed that Sir James employed the phrase take into account a number of times yesterday. But again, we say this is not a case where a decision maker has merely taken into account international obligations. This is a case where the decision maker has come to a conclusion that the decision is compatible with international obligations. And that can only be a legal conclusion. And unlike the Corner House research case, this is not a case where there's a witness statement from the decision maker saying, well, we would have come to the same view, the same conclusion, the same decision, regardless of whether or not it was compatible with the Paris Agreement. That is not the case that's being put against us. Now, the SC against Secretary of State for Work and Pensions case, and Sir James, you recall, started with this case. And this case is about whether the court could decide whether the United Kingdom had breached unincorporated UN Convention on the Rights of the Child in determining whether legislative amendments were compatible with the European Convention. And again, the finding here was that that was not justiciable. There was no government decision based on compatibility with the treaty in play in that case. And my lords, I look very carefully, Launder and Kebeling are not considered in that case, and tenability is not mentioned. The other Supreme Court decision that he referred you to was Friends of the Earth against the Transport Secretary. This is at tab 26 of the bundle. And maybe it is worth turning this one up. This was the second decision referred to by Sir James.
Launder was cited in that case.
My lord, not in the context that we're talking about. It's cited in a passage which has nothing to do with judicial review. Now, I'll repeat what the respondent says in their skeleton about this case, because in our submission it's not correct. They say, and this is at paragraph 20.2 of the skeleton, page 72 of the core bundle, they say about this Friends of the Earth case that rationality was therefore the standard of review, not only for the question of whether Paris Agreement obligations should be considered at all, and here comes the critical part, but also for the question of how they should be considered. In our submission, that's not correct, because in that case, my lords, the Secretary of State was not obliged in law to take into account the Paris Agreement, and decided in his discretion not to take them into account. So in other words, my lords, there was no basis in that case for making the question of compliance with the Paris Agreement obligations justiciable. And you can see this if we go to page 1517, at paragraph 129. They say, on the evidence, the Secretary of State certainly did ask himself the question whether he should take into account the Paris Agreement beyond the extent to which it was already reflected in the obligations under the CCA 2008, and concluded in the exercise of his discretion that it would not be appropriate to do so.
Sorry, which paragraph?
That's paragraph 129.
At page 1519.
1517.
Because it's not what it says here. In our view, both the submissions of Mr. Wolfe, which the court
Yes, that's, my apologies. Is on the evidence is the relevant quotation. It's the third sentence.
I see.
And as I say, Launder and Kebeline are not cited in this context. And what's interesting, actually, my lords, is that the Supreme Court even reserved its position on the hypothetical question as to whether there could be a challenge if the Secretary of State had not turned his mind to whether or not he should take into account the Paris Agreement. And you'll see this at paragraph 134. And of course, Lord Sales is the co-author of this judgment. This is what they say. This is a very cautious position to take. In light of the factual position, it is not necessary to decide the different question whether, if the Secretary of State had omitted to think about the Paris Agreement at all, as an unincorporated treaty, that would have constituted an error of law. That is not a straightforward issue, and we have not heard submissions on the point. We say no more about it. Now, interestingly, he formulates that hypothetical as a possible error of law, not rationality. And in our case, of course, the decision maker has exercised the discretion to take into account the Paris Agreement and has concluded that the decision was compatible with the Paris Agreement. So this is an easy case. We're within the four corners of Launder. So in our submission, my lords, nothing in these Supreme Court decisions would suggest that the Launder principle is under threat, or that there's some sort of sea change coming about how the courts should approach questions of international law more generally. Indeed, to the contrary, we have a powerful statement on behalf of the entire Supreme Court in Benker-Bush in 2019. We also have a powerful statement from this court in the Law Debenture Trust and Ukraine case. I've already given you the reference, tab 24, page 1280, paragraph 163, where the Court of Appeal accepted that the court should adjudicate the question of whether Russia exerted duress over Ukraine in the context of their international relations for the purpose of deciding whether Eurobond notes issued by Ukraine should be vitiated on the basis of duress. Now, Sir James also took you to the Appellant case, which is at tab 36, and he noted, as I did, the domestic statutory link to the Refugee Convention, and then referred to the passage where Lord Steyn applied Article 31 of the Vienna Convention. And Sir James said that I said, aha, look at how the court interprets a treaty. Now, I'm grateful, of course, to my learned friend for crediting me with a submission of such eloquence, which I'm not sure I actually did make. But if my rhetorical powers did rise to that level, then, my lords, I would have said, aha, in respect of the Occidental Petroleum line of cases. And you recall I took you to Occidental Petroleum, Czech Republic against EMV, GPF and Poland, where you have an impressive application of the Vienna Convention principles of interpretation to unincorporated treaties. Indeed, my lords, in those cases, the United Kingdom is not even a party to the international treaties in question. In Occidental Petroleum, it was a treaty between the United States and Ecuador. In the Czech Republic against EMV, we're talking about a treaty between the Belgium and Luxembourg and the Czech Republic. And in GPF and Poland, a treaty between Belgium and Luxembourg and Poland. So, in those cases, English court coming to a definitive view of the meaning of an unincorporated treaty to which the UK is not even a party, based upon the application of Articles 31 and 32 of the Vienna Convention. My lords, the truth of the matter is that the English courts apply the same approach to interpreting the treaty
whether the treaty is incorporated by scheduling it to a parliamentary act, and I think Sir James referred to the example of the Vienna Convention on Consular Relations, or whether it's a statutory link to that treaty, such as the Refugee Convention that we saw in Adam, or in circumstances where the United Kingdom is not even a party to the treaty. And we see that with the Occidental Petroleum line of cases. Now, my lords, unless I can assist you further on those issues, then those are our submissions on ground 2.
Thank you.
My lords, I have listed here anyway 11 points in reply. I'm going to deal with the temperature goal and effective interpretation, the issue of policy change, third, development versus climate, fourth, Mrs. Justice Thornton's interpretation, 5, finance flows and Article 9.5 of the treaty, 6, national versus global emissions, 7, NDCs, which are said to be the answer to this problem, 8, the climate change report, 9, Wood-Mackenzie and the climate change report, 10, scope 3, and 11, it's all happening anyway. But I want to open by saying, my lords, that your lordships have before you a coherent interpretation of the Paris Agreement that crucially gives effect to its object and purpose, and you find that in the judgment of Mrs. Justice Thornton below. And that interpretation is reflected in the respondents' policy since at least March 2021, but likely prior to that in the CDC policy of 1 July 2020, and indeed prior to that in the Green Finance Strategy. And indeed, it is now part of the United Kingdom's NDC. It has been submitted to the United Nations pursuant to Article 4.1 by the United Kingdom to the UN. And the position is the same globally. And I'd like to take you to a document I didn't take you to in my opening, which is an EU Council document. It in fact dates back to November 2019. You'll find it in the 19th tab of the supplementary bundle. And there are others of other international banks, etc. But this shows you the position as found by Mrs. Justice Thornton. Just starting on page 106. And this is a council of...
106.
167. It's tab 19.
And I've got 167. Which page?
Next page. I just want to tell you what it is first. First of all, it's the council. And the council, I'm sure you'll all be aware, is made up of ministers. Now, in fact, I didn't take you to it, but in the Green Finance Strategy of 2019, it's stated that despite leaving the EU, the United Kingdom will keep up with EU policy in relation to the Paris Agreement. But putting that aside, let's start on page 168. Reiterates the importance of making swift and ambitious progress on the long-term goals of the Paris Agreement, especially making finance flows consistent with the pathway towards low greenhouse gas emissions and climate-resilient development in line with the findings, and I emphasise this, of the Intergovernmental Panel on Climate Change Special Report 1.5. And the reason I emphasise this, and I'll come to this in a moment, is that Sir James suggested, indeed he argued, that there were no pathways and there was no temperature. Well, there was a temperature goal, but there were no pathways, effectively denying the existence of SR 1.5. In this regard, welcomes international commitment to assess the collective progress through the global stocktake under the Paris Agreement. And if you'll recall, I showed you the global stocktake. That is a stocktake whereby the UN looks at progress towards these goals. And it does that by reference to various information submitted by the states as to what they have achieved.
I mean, you've got 11 points and you've got 20 minutes.
Well, my lord,
how's that really going to work if you're going to read out tracts of new documents? I mean, this simply says that 21C is a goal, which is really the same as a purpose, right? Is a goal.
Well, my lord, I hope you're going to be patient with me. This is an incredibly important
I'm afraid, Miss Simon, we made it very clear at the beginning we are unable to sit longer than 4:15. I'll talk to my colleagues and we might be able to give you an extra 5 minutes. It's not possible to extend the court days in this court. You'll have to put your reply in writing.
All right, well, I'm going to quickly ask you then to sideline, and I may just say a few words about this document, which I think will assist your lordship. Just if you carry on a bit, it says a bit further down, sustainable. There's a taking steps to align financial flows with low carbon and climate resilient development, and including through the EU Action Plan. Now, if you turn to the next page, you see halfway down 3, rapid phasing down of public and private financing for emission-intensive, environmentally harmful projects and assets. On the next page...
What does this point go to?
What does this point go to?
Yes.
It goes to the point that the interpretation by Mrs. Justice Thornton is equally the interpretation adopted by the Council of Ministers in a declaration. Now, my lord, if you accept the interpretation of Mrs. Justice Thornton, I don't need to do any more work.
But what she does in paragraph 268 is to repeat the words of Article 2.1c, and in effect say this is a freestanding, binding obligation. You don't need to look at anything else.
Well, I would add, and I think I did, at least I hope I did, in my submissions, add a level to that, because central in my analysis, or our submission, is Article 3. And it is Article 3 that ties together Article 4.1 and the objectives in Article 2, because I agree that Article 2 sets out the objectives of the treaty. Article 3 sets out what states must do by reference to the Articles 4, 7, 9 and 11. That is my reading of...
Well, if that's right, then your interpretation does not make binding the obligation in 2.1c.
Well, it is binding through those obligations in 3.
Well, what does that mean?
Well, it means what I hope I had explained, that it means that you have to undertake, and I don't want to use the incorrect language, but I believe it says undertake and communicate ambitious objectives to achieve the undertake and communicate ambitious steps.
I think we should look.
Well, let's look at it. Before I do actually want you to sideline, because it is important, on page 171, top paragraph, 6th line down, in this regard, encourages multilateral development banks to adopt responsible investment policies and to phase out financing of fossil fuels. So I just do want to highlight that to you. I accept it doesn't determine anything in law, but it's nonetheless important that you're aware that this is the position pretty much globally. Now, let's go to the Paris Agreement. Yes.
Is this your first of 11 points now?
No, I just was being, I'm being taken off my, you wanted to go to the Paris Agreement, my lord, to look at the terms of 3.
Well, I wanted to have your answer to the submission that Sir James made about the meaning of this agreement, which was that Article 2 is said by Article 3 to be the purpose of the agreement, and the obligations in the agreement are in Articles 4, 7, 9, 10, 11 and 13, with the purpose of A, B and C.
Well, I agree with that interpretation myself. I also support the interpretation of Mrs. Justice Thornton. Submissions I made yesterday.
Yes, but they're not consistent, because Mrs. Justice
I put them as
Thornton.
alternatives. My lord, I'm entitled to say that they are alternative interpretations. A senior judge has found that interpretation. I'm entitled to say that it is a legitimate interpretation by a senior judge.
Nobody says it's not legitimate. Of course,
No,
it's legitimate.
well, my lord,
question is whether it's
the
right.
way I explained our case yesterday was by reference to Article 3.
Yeah. Okay. Look, I've put the point.
I don't have to.
Let's carry on.
I don't have to say that Mrs. Justice Thornton didn't get it right. She got it right from our perspective. I also put to you the interpretation that the obligation is in 3. The United Kingdom is discharging that obligation currently by listing the decision no longer to fund any fossil fuel projects in the world where those fossil fuels are for the global market. Now that is in the United Kingdom's NDC.
Right.
And we, so before this court, we have had no alternative interpretation. And we have sought an interpretation now for more than 2 years. We do not have an interpretation as to what the Paris Agreement means. And as such, that interpretation, and indeed the interpretation of Lord Justice Stuart-Smith, which comes effectively to the same, does not meet the obligation to interpret a treaty to give meaning and effect to all of its provisions and to make it overall coherent. Now, Sir James Eadie has adopted that interpretation. It is an interpretation that renders the Paris Agreement entirely nugatory. Turning then to the temperature goal, which was my first point, that temperature goal is a crucial, central part of Paris. Indeed, it is Paris. And I explained to you why that was the case. Because the temperature goal, is the level that countries have globally agreed is acceptable to take efforts to achieve. And I explained that that was a compromise. Because for some countries, like small island states, 1.5 degrees is the end. So other countries were quite happy to have 2.5. But the temperature goal signifies the degree to which emissions, or the degree by which emissions must be reduced. It signifies the pathway, and it signifies the actual material efforts that had to be made. And by the time it was adopted, all the parties knew what that meant in terms of budgets, in terms of emission reductions. Now, Sir James said, and to quote, he said, "There's no Paris Agreement pathway and there's no emissions threshold." And he quoted from Griffith, paragraph 137. And that is a fundamental error of assessment. It is a fundamental misunderstanding of the Paris Agreement. And indeed, if that was the basis on which Paris Agreement compatibility was approached, then it was plainly wrong. it was an error of assessment. We know from their evidence that they did not look at the UNEP emissions gap report, nor the production gap report, and you find that in Lou Taylor, SB 60, page 478, paragraph 92. Now, Sir James Eadie contends that those documents are of no more relevance or value, same he says about SR 1.5, as the IEA report. With respect, that is not correct. These are documents that are inherently connected with the Paris Agreement, because all the obligations in the Paris Agreement come back to the temperature goal, and the temperature goal has to be met by particular steps which can be calculated in terms of emissions reductions. And as the science moves and as an understanding of exactly where we are in the trajectory changes, the steps that need to be taken to meet that goal also change. And I explained to you why the IPC pathways and the UNEP reports are so important, and why they are referred to in the decision by the Conference of Parties in Decision 1, CP 21, by which Paris was adopted. The reason is that they explain what needs to be done. Now, Sir James Eadie emphasised paragraph 231 of Lord Justice Stuart-Smith as being the central correct approach. And if I can just take you to that bit of the judgment, because he didn't do that. That said, in my judgment, UKEF adopted a reasonable approach to the complicated question of whether the project was in overall alignment with Mozambique's stated climate policies once the Paris Agreement is approached, on the basis that it does not give rise to hard-edged freestanding obligations but should be seen as a composite package of aims and aspirations that may be, and in this case are, in tension or frankly irreconcilable. UKEF's approach, which involved recognition of those conflicting aims and aspirations and an evaluative balancing exercise in order to come to that conclusion, cannot be criticised. So the United Kingdom cannot be criticised for saying that Paris contains irreconcilable objectives and basically doesn't mean anything, because that is effectively what is being said. And it is no accident, my lord, that when Lord Justice Bean asked, what does 2.1c mean, there was no answer except what it did not mean. And this is the opposite of an effective interpretation. It's an interpretation to render an internationally binding treaty wholly ineffective and meaningless. And the consequences of this court reaching such a conclusion would be far-ranging, to put it mildly. It would be the first domino, the UK domino, that would be followed swiftly by the other dominoes, the other 196 parties to the Paris Agreement. My second point, my lord, relates to policy change by the government. Sir James's answer is that whatever the UK says or does in relation to the financing of commercial opening up of fossil fuel reserves, it is permissible under the Paris Agreement, however great the emissions. And indeed, Maxwell Griffin's statement says there is no threshold. In effect, that policy has nothing to do with the Paris Agreement. Never mind that the CDC said it was, and that the UK now says it is. His point was that no policy applied to UKEF, and he took you to the Green Finance Strategy as the only relevant policy. Now, 3 points. First, my lords, this is not a challenge to compliance with policy. In fact, the relevant policy that applied to UKEF is in the 14th tab of the supplementary bundle. You'll find it at 109, page 109. I took you to it. policy is to comply with international agreements. And just to take you to it again, just to remind you, there is reference both to the OECD common approaches that specifically refers to compliance with the UNFCCC and Paris under it, and then there is here reference to also to compliance with international agreements. So whether directly in this document or via the OECD common approaches that is referred to in this document, the policy was to comply with international agreements, including the Paris Agreement. And then if we go to tab 42, you'll see in paragraph 3, UKEF has a requirement to consider climate change risks as part of its
Sorry,
consideration.
I'm not clear of the page.
Page 350. UKEF has a requirement to consider climate change risks as part of its consideration of support for the project, and a climate change report has been provided. So whether it's the Paris Agreement or climate change risks, the UKEF policy was to carry out that assessment and comply with international agreements. And UKEF purported to do so. It purported to apply its policy, and it decided that financing this project was compatible, one, with a low emissions pathway, and two, with its duties to Mozambique. And I'm not going to give you all the references I did yesterday. The respondents did not argue otherwise in front of this court today. This court, my lords, cannot proceed on the basis that the respondents are saying something different from what they are saying. You must take their pleadings and what they said below and say in front of you as their evidence. The second point is that Sir James Eadie explains that it is not now or ever was 1st of July 20 CDC or Green Finance Strategy or at any time incompatible with the Paris Agreement for such projects to be financed. And indeed, government policy today effectively has nothing to do with the Paris Agreement. Indeed, he was forced to say that the reason the UK is now saying that we won't give UKEF money, forget CDC and the rest of it, we're not going to give UKEF money to companies that help, like rigs, for example, an oil rig, we're not going to help them with a guarantee, is because we want UK companies to move their work to renewables. As if UK businesses decide what's commercial by reference to whether they can get a loan from UKEF. Frankly, this is an absurd analysis. And indeed, if you look at the supplementary bundle, page 336, I took you to this in the submissions. One of the reasons Mr. Taylor said to the Secretary of State, we really ought to give this loan, is because there's a real possibility of another £1 billion worth of contracts with the Exxon development in Area 4. It cannot seriously be said that the United Kingdom is giving up billions of pounds worth of potential contracts because somehow it thinks that its businesses will move to renewables because UKEF is not going to give guarantees. And why would it do this when every other country on its analysis can provide those rigs, can finance those opening up of fossil fuels, and can get contracts for their companies? Now, frankly, if France is perfectly entitled to lend €1 billion to Total so that they can get the contracts for the rig for French businesses, why would they not do so? And I do not accept that the UK policy on fossil fuels, announced at COP26 with great clamour, is something to do with trying to persuade British businesses to start making solar panels. And indeed, nor can it be said that, well, we're also doing it because we believe that we should do our best for climate change. What is the point in the United Kingdom doing its best for climate change if every other country can carry on financing Total, Exxon, Chevron, Shell to open up these reserves? This is why this is all about compliance. And it is all about agreements reached at an international level as a matter of urgency in order to stop this happening.
So your submission is that the policy change is to be taken as a statement by the British government that the Paris Agreement requires them not to finance overseas projects relating to fossil fuels.
What it is a statement under Article 3, as now evidenced in the NDC, that it is undertaking ambitious efforts, one effort being the ending of finance of fossil fuels. So it is certainly complying under Article 3 with its obligation to end finance for new fossil fuel opening up for the global market, and I emphasise that.
Well, I'd like an answer to the question I asked, but it's up to you. I mean, I get that. That's putting it in terms of, it's putting it in different terms, but this case has pretty well been argued as to whether the Paris Agreement prevents, as a matter of law, that's your case, prevents the UK government financing overseas
Yes.
fossil fuel
Yes.
projects.
My Lord, I don't shy away from that. I don't shy away from that. I say that the financing of fossil fuels would be undermining ambitious efforts to reach the temperature goals.
So your case is that the policy change of the to the new policy is an indication that the British government accepts that the meaning of the Paris Agreement is what you say it is.
It's more than an indication. It's a legal statement in the NDC that these are ambitious efforts. And therefore, if you do the opposite, you are entirely, you are doing the opposite of what you say you need to do to meet the temperature goal. And it's absurd, frankly.
We've not been shown the NDC, have we?
I have shown you the NDC, yes. I showed you it very swiftly. It just has a line saying ending fossil fuels. We can send you the reference, or we'll give it to you. But it's the same point one can bring in when looking at CDC and ODA and all the rest of it. And I made this point yesterday. I'm sorry, my lord, if we can go to 20 past it, I'd be very grateful. The same point feeds in to the argument that somehow stuff we put in the NDC we need to do. But we can do outside of the NDC something that completely undermines everything we're doing in the NDC. And that is effectively the argument. Only if we write it in the NDC do we have to do it. And the fact that we've written it in the NDC, that we're going to, for example, send lots of solar panels or help with a hydropower project. So we can tell the UN in our annual statement that we've reduced emissions in Mozambique by 1 gigaton, whatever, 35 megatons, because we have sent some equipment for a dam, right? And we don't mention the negatives. We don't mention the 805 megatons coming from the fossil fuel project, because they're in a different box. But the UN says, well, the United Kingdom has helped, and that's what they measure. That is not ambitious efforts. It is undermining the efforts that you have notified. And we say that the idea of sort of separating CDC, ODA and UKEF, we have no witness statement, no explanation. All of these bodies are now under the FCO. The very least one might have expected would have been a witness statement from the Foreign Secretary. or at least from the permanent secretary in the Foreign Office. And it is no coincidence. It may well, as my lords
Well, I
pointed-
mean, you say that, but it is pretty clear, isn't it, that there were different views in government and different views between government departments up until the change in policy in December 2020, whenever it was, March 21. I mean, and the policies that we were shown originally did refer to the ODA, which is not the UKEF.
Yes, but I've made my point on that. The
Well, you say
obligations.
what? It's
Well, the
unrealistic.
obligations are of the United Kingdom. You can have two columns. We're not going to do anything bad, CDC, ODA, and then with this lot, this bunch of money.
Absolutely. I mean, if you submit it's incoherent, it was incoherent at that stage. I mean, I perfectly see that. But all I'm concerned about is knowing what it actually was. And what it actually was seems to have been different things for different bodies until the big fanfare announcement later.
But what one would have expected, with the greatest of respect, is an explanation.
And now I take that point. I've got that point. No
I
explanation.
can't speculate.
No, I mean, I've got that point. Yeah.
The points made about development, this is my third point, the points made about development, and I went over those in great detail. I urge you to look at the OECD document.
Sorry, the
The
point
idea
about
that there's
development-
the idea that there is a counterweight of development versus climate
Oh,
change.
right.
And you were referred at the end of my learned friend's submissions to a recital, but that recital didn't come from the Paris Agreement. It came from the UNFCCC. And I tried to explain, and I hope I succeeded, to explain that there was a huge change between the UNFCCC and the Paris Agreement. And that big change was the fact that in Paris, all parties committed to the temperature limit. Prior to that, only developed countries under Kyoto had obligations to reduce to meet the goal. And that was a fundamental change. And because developed countries are going to suffer already at 1.5 degrees, they were willing to make the various compromises that it involved. Now, we saw the UNEP report predicting an average of 3.6 degree temperature rise at current trajectories as a global average. And of course, it's even worse for Mozambique. We are not in an abstract, theoretical position. You heard my quotes from Alok Sharma, and I will not repeat them. We are in a situation where we are dealing with scientific truth. And that is why developing countries signed up to this agreement. They didn't give in and sacrifice money. These countries wanted the temperature limit to be lower. And I think one should not be naive either. When a global energy producer set to make billions, if not trillions, from this project, and similar other projects across the world, accuses friends of the earth of kicking the ladder, it is offensive. Indeed, it is not just offensive, it is Kafkaesque to talk about a situation where there is this word development, finance, and GDP, when we are actually talking about countries that will no longer be viable. Now, just finally on finance, my lord appeared to understand, and Sir James Eadie did not correct you if this was the understanding. Finance under Article 9 is specifically provided in Article 9 for governments to provide money to assist developing countries with climate resilience. It is not finance to Total to enable them to open up reserves in order to produce revenue, some of which may get to developing.
I don't think it was said that that was an Article 9 finance.
Article 9 is specifically, that is why my lords need to look at the entire agreement, because the entire agreement is supposed to provide mechanisms whereby finance does move, because evidently the entire situation represents a global injustice that is perhaps insurmountable. But this is the agreement that has been reached to try and deal with where we have arrived in terms of ecological catastrophe. And NDCs are not the answer. I showed you the emissions gap report, and I showed you that when adopting Paris, one of the reasons for adopting Paris was that national commitments previously under Kyoto had shown the vast gap between what was promised and what was necessary. And as a result, the parties came together and they agreed Paris, and they added this mechanism, climate finance. Not climate finance, climate financial flows as a central and core objective. Because what Paris recognized and the parties recognized was that the entire financial system needed to move if we had any chance of meeting the temperature goals. And the United Kingdom, to be fair to the United Kingdom, has been incredibly progressive and pushed very, very hard. It's pushed the City of London, it's pushed the pensions, it's pushed Lloyd's Insurance. The city itself is reorientating. This is not about a supply-side approach. This is not, as my learned friend suggests, about demand for gas abating. This is about reorientating finance in order to meet this temperature goal along the pathway. Now, I haven't got time to go into the CCR. I urge you one thing about the CCR. Below, the case was very different. We went through all the evidence. Now, you were referred to the witness statements of the respondents. As a result of those witness statements, we produced an extremely detailed Part 18. As a consequence, we got a lot of evidence and material, much of which undermines the paragraphs to which you were referred. The facts are the facts as found in the judgments of Stuart-Smith and Mrs. Justice Thornton. Stuart-Smith 60, 64, 66, 172 to 173, 217. The judgment of Mrs. Justice Thornton 285 to 87, 294 to 301, 303 and 333. You have the original materials, most of them. The facts are not to be read directly from the respondents' witness statements, which were followed by disclosure, which led to the judgment.
Samuel, you don't quarrel, as I understand it, with the long recital of the facts in Lord Justice Stuart-Smith's judgment. You obviously quarrel with his conclusions, but
I don't believe that there was anything of great import that was problematic. I will check again, but I think that the facts as set out in the two judgments are correct, and we accept. They are the facts anyway for the Court of Appeal.
Well, you're going to have the opportunity to put in a short written submission containing your remaining, I think, 8 points. That is fine, but it'll have to be done tomorrow, by tomorrow night, please. And
I don't think I need to. I just would like to correct the error I made with respect to my friend. He's absolutely correct in terms of the calculation. That was my error.
sorry, what was
There was an error about the emissions. That was my error. In fact, it's 6 megatons per year times 25, not 13.8.
Okay, well,
so I just apologise to the court for that. And I urge on you, my lordships.
Well, I don't want to put you under pressure, and if in the heat of the moment you, or rather if in the calm of later moments you do wish to make sure we understand any of the subsequent 8 points, we will receive a short written submission by close of play tomorrow, however late, from you, provided they're in proper reply form, not all sorts of new points, obviously. Okay.
Well, I apologise.
No,
Thank
you don't need to apologise. It's a very difficult, it's a very important case, and we've had some very important arguments on both sides, which we will take time to consider. And we will deliver our judgments in the usual way. We will send a draft. This judgment is likely to be particularly sensitive when delivered, and therefore it is extremely important that the parties take very seriously, the lawyers take very seriously the injunction in Counsel General for Wales about the proper use of a judgment in draft. You won't be given much time to consider it, I'm afraid, because of its sensitivity. Please provide typographical corrections of fact, not of the judgments, and use the draft to agree, if you can, an order and the disposition of the case and costs. If you can't, we'll decide those questions in writing in due course. If you can't, if because you get such a short time, which is possible, you can't really realistically agree an order and costs, that's not a problem. Take your time to do so. Just tell us a timetable that you require for the exchange of submissions, or indeed to continue your discussions after hand down. The important thing is that you adhere to the embargo and that the judgment is handed down swiftly because of its importance, which all the parties, I think, understand. So it only remains for me to thank you all very much, both counsel and solicitors. There's obviously a tremendous amount of hard work gone into this case, which we very much appreciate, and we will, I hope, do justice to that hard work in considering our judgments. Thank you.